it'll be good. Yeah, I love that name. I love that name. And Idiot Wind, I think we might get some more with Tracy Sands on the stand. So that's the lead detective, lead investigator from the prosecution office. I think we'll get some questions. We'll either get some questions answered or we'll have more questions when they get off the stand. Who knows with this case? So let's make this bigger. Zoom this in. And we're reading it this way because I don't want to spend $50 to download this document. So we're going to go through it with the browser. Let's see. So they filed this yesterday. We heard about it in court. This is them requesting the charges that they want to be read to the jury before they deliberate. And first thing is the indictment. So we've gone over the 12 counts. We're going to get into them in detail. Now, as we go through this one by one, what I think will be interesting is when we get to counts, let's say 6 through 10, maybe even 11. And I think this is where we'll get to the area where there's a better chance that Kassotis has a chance for jurors to say, you know what, I'm not sure that the state actually proved this to the standard that they need to prove it to. So count 1 is the malice murder. And maybe there's a way I can get rid of this little... Yeah, that's way better. So malice murder, that's 16-15-1A, a felony. For that, the said Nicholas James Kassotis, aka Nicholas Stark, in Liberty County, between the 21st day. So this is the date range, you guys. This is where they're estimating. They want to charge this date range, the 21st day of November through the 29th day of November 2022. It's 8 days. The exact date of the offense being unknown to the grand jury, did unlawfully, with malice aforethought, cause the death of Mindy Mebane Kassotis, a human being, by multiple traumatic injuries to the body, contrary to the laws of said state, the good order, peace, and dignity thereof. I think this is a huge hurdle that we've got to get over for the defense. I don't know if this one's looking good. My opinion. Count 2, the jurors. What do we got here? We have the felony murder, that's 16-15-1C, a felony in the County of Liberty in the state of Georgia, again between the 21st day of November 2022 and the 29th day of November. So that same range. Did commit the offense of murder when the accused caused the death of Mindy Mebane Kassotis, a human being, irrespective of malice. So they don't need to find malice. They could get him on this felony murder. By causing multiple traumatic injuries to the body with an unknown object, which when used offensively against a person is likely to, or actually does result in serious bodily injury in violation of 16-15-1C, contrary to the laws of said state. Count 3. We get it, and I don't know, do you guys want to do a little poll on that? Do you guys think that there might be... what if maybe he seemed emotional? Maybe the jury thinks he's genuinely upset when he's talking about how Mindy's no longer with us and he's letting people know that she died. Maybe they believe he's actually crying. So maybe they say, you know what? We don't think malice murder. We think he killed her. He used tools to do it. It was offensive. But maybe there wasn't malice. If we get to count 3, we've got aggravated assault, 16-5-21. Again, the same date range, so the same transaction, guys. The same transaction that maybe caused this death. Did he commit aggravated assault? With an unknown object, an object which was, when used offensively against a person, is likely to, or actually does result in serious bodily injury by causing multiple traumatic injuries to the body in violation of OCGA 16-5-21. Contrary to the laws of said state. NY Bab says Doug should start with AJ's closing about reasonable doubt. He's got to bring out, do you guys remember the reasonable doubt chart visual he used in the YSL closings? The big poster? Yeah, Idiot Wayne, that's true. Why is nobody calling Wayne? Maybe they don't want to subject him to cross. Because he's there, right? So it's not like it's a hurdle for him to get into the courtroom. So I don't know. Tracy Sands is the prosecutor that took the stand to introduce the interrogation, the 2 interviews. And he's also the questioning, the actual meaningful questioning. The state is going to close out their case in chief by putting him on the stand last. So they expect to put on 1 more witness that we're waiting for them to arrive. And then they're going to put Tracy Sands on. And there's going to be a lot in that testimony, I think. So that's the guy you've been seeing in court already. The guy that was just sitting up there while we were listening to the calls. So count 5 is possession of a knife during commission of a felony. A felony for the said accused in the county of Liberty in the state of Georgia on the 29th day of November 2022. So this possession of knife during the commission of a felony is in relation to the disposal or dismemberment of the body. So one of these felonies below. This is not possession of a knife during the actual carrying out of the killing. They're not giving us that date range. Did unlawfully have on his person a knife having a blade of 3 inches in length during the commission of the crime of concealing death of another, a felony, a crime involving the person of Mindy Mebane Kassotis, 16-11-106. Oh, Aaron's here for jury charges. This is the proposed jury charges from the state. So not final instructions. We don't know if Doug is going to challenge or what he's going to challenge about him. But we're just going through it until they're back from their recess. So let's see. Now we're getting into the tools. So these are all going to be 16-7-20. They're all felonies. And they're all, let's see. Hold on. This one says the 29th, 28th, 29th, 29th. Uh-oh. Interesting. Interesting. So this is what the indictment says. So the first one, felony, count 6, the 29th of November 2022, did unlawfully have in his possession an insulation knife, a device used in the commission of removal of body parts from the scene of death or dismemberment, with the intent to make use of said tool in the commission of said crime, in violation of 16-7-20. Now count 7 is the deer processing kit. That 7-piece kit from Bass Pro Shops that was purchased on the 28th day of November. They're charging him here in count 7 with possession of tools for the commission of crime on the 28th day of November, that he did unlawfully have in possession a deer processing kit, a device used in the commission of removal of body parts from the scene of death or dismemberment, with the intent to make use of said tool in the commission of said crime in violation of OCGA 16-7-20. Now maybe that's a permissible way to do it. That's kind of interesting to me that you can use the date of purchase. Because for these other ones, the installation knife was purchased on the 29th, but these tubs, this other stuff that they're saying was a tool, that's not the purchase date. So it's kind of weird that they're using the 28th day here. I don't know. I don't know. The 8th count. We've got possession of tools. This one's the 29th day of November, and this one's relating to, what do we got? The rubberized tubs. So there were 2 rubberized tubs. It's being considered one tool here. Count 9, the 29th of November. This is the Ford Explorer for being used in the commission of removal of body parts from scene of death or dismemberment. And then count 10 is the shovel. Again, used the 29th for the commission of removal of body parts from the scene of death or dismemberment. If we get to count 11, this is the removal of body parts from the scene. They're doing the 29th day of November 2022, saying that they did unlawfully remove from the scene of death and dismemberment of Mindy Mebane Kassotis a head, torso with arms, a right leg and left leg, each item being a human body part in violation of OCGA 16-12-161. And what's interesting here is I was wondering until I read this, if the removal of parts could count, since the parts were spread out from each other, could that be considered a removal from the scene if the dismemberment had occurred like at one position of where the body parts was found and then everything was moved everywhere else? But this is all the parts inclusive, and it's and. So my reading of this means that their argument is she was killed and dismembered first, then transported in the bins, and then the parts were scattered. Which is gross to talk about, sorry. I was just trying to logically process it. And Aaron, shout out to Aaron, says it's the language possession of tools for the commission of a crime rather than during. It's an allegation that he bought the tools specifically for the crime, going towards the malice. There we go. Thank you, Aaron. And then count 12 would be the tampering with evidence, a misdemeanor. So we're taking it down a notch. For the said accused in the county of Liberty in the state of Georgia on the 29th day of November 2022, that he did knowingly alter, conceal, and disguise physical evidence, to wit, the body of Mindy Mebbing Kassotis, a knife, rubberized tubs and cleaning wipes, said evidence including the prosecution of the offense of murder, with intent to prevent and obstruct the apprehension of prosecution of Nicholas James Kassotis by destroying biological evidence and concealing tools from the commission of the crime, in violation of 16-10-94. So those are the counts, guys. That was the indictment. That was back from the 20th of February of last year. And let's get into requests for more charges. So, the issue and plea of not guilty. And a lot of this comes down to the language. Some of this could be from model instructions. Some of it might be changed. And we don't know if Doug's going to be okay with this or have challenges for it. The defendant has entered a plea of not guilty to this indictment. The indictment and the plea form that the issues that you are to decide. Neither the indictment nor the plea of not guilty should be considered as evidence. Now, the language of presumption of innocence, burden of proof, and reasonable doubt. The defendant is presumed to be innocent until proven guilty. And it seems like they're using model instructions, because we got this up here. The defendant is presumed to be innocent until proven guilty. The defendant enters upon the trial of the case with the presumption of innocence in his or her favor. This presumption remains with the defendant until it is overcome by the state with evidence that is sufficient to convince you beyond a reasonable doubt that the defendant is guilty of the offenses charged. No person shall be convicted of any crime unless and until each element of the crime is proven beyond a reasonable doubt. The burden of proof rests upon the state to prove every material allegation of the indictment and every essential element of the crime charged beyond a reasonable doubt. There is no burden of proof upon the defendant whatsoever, and the burden never shifts to the defendant to introduce evidence or to prove innocence. When a defense, except insanity, is raised... Oh, are they going to include this? Are they going to leave this in here? They could take this out, right? Because in parentheses. But it says when a defense, except insanity, is raised by the evidence, the burden is on the state to negate or disprove it beyond a reasonable doubt. Cool. I think this is helpful for the defense if they leave this in. Because it's reminding the jury that just because the defense mentioned Jim, the defendant doesn't have to prove the existence of Jim. However, the state is not required to prove the guilt of the accused beyond all doubt or to a mathematical certainty. A reasonable doubt means just what it says. A reasonable doubt is a doubt of a fair-minded, impartial juror, honestly seeking the truth. A reasonable doubt is a doubt based upon common sense and reason. It does not mean a vague or arbitrary doubt, but is a doubt for which a reason can be given, arising from a consideration of the evidence, a lack of evidence, or a conflict in the evidence. After giving consideration to all the facts and circumstances in this case, if your minds are wavering, unsettled, or unsatisfied, then that is a doubt of the law, and you must acquit the defendant. But if that doubt does not exist in your minds as to the guilt of the accused, then you would be authorized to convict the defendant. If the state fails to prove the defendant's guilt beyond a reasonable doubt, it would be your duty to acquit the defendant. Now we're getting into charge 4. The jury judges a fact of law and fact. Members of the jury, this would be the judge reading it. Members of the jury, it is my duty and responsibility to determine the law that applies to this case and to instruct you on that law. You are bound by these instructions. It is your responsibility to determine the facts of the case from all the evidence presented. Then you must apply the law I give you in the charge to the facts as you find them to be. All right, so now charge on evidence. So this is all model instructions, it looks like. Ooh, I'm looking over at the chat. Yeah, and Shanikia says, Aaron, you're always so awesome. Idiot Wind. I didn't know this about. I just started watching testimony from the Zachary Hughes trial. I forget what I was watching when that was going on. Maybe Karen Reed was happening the same time. But they had some jury interviews, it looks like, where they said that before he testified, they were going to vote not guilty because they felt like there was so much missing info and they were so confused. And now he is guilty and he is gone for life. Oof. Oof. That's a crazy thing. That's what I'm saying. Like the decision to take the stand. I get that some cases need it. Some cases, especially if you're required to take the affirmative and you need to get evidence on the record that wasn't otherwise on the record from any other witness. Sure. But here, I think the jury heard about Jim. They might not know what to make of Jim, but these instructions could be helpful for that confusion in the defendant's favor. But if you let this guy get up there and chatterbox away into contradictions, things that don't make sense, you get a chance to press him. Because quite frankly, I don't think in these interrogations that Sands or Frost really pressed back. They just let him talk. Probably strategically so for that moment in time. But if you were to take the stand now, you're going to have this prosecutor get to corner him. So, but at the same time, he's an attorney that felt he knew better and could just speak to cops. He might think it's a good move to get on the stand. Yeah, I don't think so either. And Brooklyn, I would agree that Doug is probably advising against it, but it's ultimately the client's choice, so. Ooh, and Neri says, I can see a world in which him taking the stand actually works out for him. I think the chance of that happening are very low, though. I just don't think it's impossible per se. Yep, I agree. I think one thing to consider is we did get to... I think taking the stand can humanize somebody, like you get to hear them speak, but we did get to hear a voice and see that this is like a person that has words, right? They can talk, they can have a conversation. We got to have a little bit of that, hey, this person's a person with the interviews. Yeah, Laundered Amber, this is where I am, I think. Kassotis, do not take the stand. Your mouth has already made your defense hard enough. So here, this looks like a model instruction on evidence. So your oath requires that you will decide this case based on the evidence. Evidence is the means by which any fact that is put in issue is established or disproved. Evidence includes all of the testimony of the witnesses, or the equivalent, such as depositions, and any exhibits admitted during the trial. Stipulations of the attorneys, that is, any facts to which the attorneys have agreed with approval by the court, matters of which the court has taken judicial notice. Evidence does not include the indictment, the plea of not guilty, opening or closing remarks of the attorneys, or questions asked by the attorneys. So, I think pretty familiar to us, pretty standard. Direct and circumstantial evidence. I think this is an important instruction. Evidence may be either direct or circumstantial, or both. In considering the evidence, you may use reasoning and common sense to make deductions and reach conclusions. You should not be concerned about whether the evidence is direct or circumstantial. Direct evidence is the testimony of a person who asserts that he or she has actual knowledge of a fact, such as an eyewitness, such as by personally observing or otherwise witnessing that fact. Circumstantial evidence is proof of a set of facts and circumstances that tend to prove or disprove another fact by inference. That is, by consistency with such fact or elimination of other facts. There is no legal difference in the weight you may give to either direct or circumstantial evidence. And then let's see. You would be authorized to convict only if the evidence, whether direct, circumstantial, or both, excludes all reasonable theories of innocence and proves the guilt of the accused beyond a reasonable doubt. I feel like if this was the YSL trial, they would be challenging this language. The prosecution would hate this language. They'd want to customize it. Oracle Cat, enjoy your nap. And shout out again to Broken Baker. Love it over there. And he's got a soothing voice for nap time, I think. Glad you got to hang out with us. Credibility of witnesses. And they have a note here, so I would assume this isn't going to be read. If the judge and Doug, if everyone agrees to this charge, this part wouldn't be read, but I want to see what the note says. So the note says, the committee removed intelligence as a credibility factor from the criminal charge on credibility of witnesses based on McKenzie v. State. However, the federal rules recodify it. Query, what if the defense brings in a world-renowned DNA expert who is a certified genius to testify versus a seemingly bureaucratic, quote, expert for the state? And the defense requests the charge including intelligence. The cases prohibiting the use of intelligence in charge are a seeming egalitarian knee-jerk against correlating intelligence and honesty. But credibility also may depend on competency. The charge is neutrally drawn and can be adequately argued by either side. Oh! The jury must determine the credibility of the witnesses. Oh, this is the charge now, not just the note. The jury must determine the credibility of the witnesses. In deciding this, you may consider all the facts and circumstances of the case, including the witness's manner of testifying, their intelligence, their means and opportunity of knowing the facts about which they testify, the nature of the facts about which they testify, the probability or improbability of their testimony, their interest or lack of interest in the outcome of this case, and their personal credibility as you observe it. So there we go. Okay, wait. So the note, there's a footnote for the note that says note. Or where's this footnote attached to? I think this is a general note. So this is confusing, but I think this is a general note for this whole charge, that in a criminal case, use caution in giving if the defendant testifies. Huh. Expert witness. Testimony has been given in this case by certain witnesses who are termed experts. Expert witnesses are those who, because of their training and experience, possess knowledge in a particular field that is not common knowledge or known to the average citizen. The law permits expert witnesses to give their opinions based upon that training and experience. You are not required to accept the testimony of any witnesses, expert or otherwise. Testimony of an expert, like that of all witnesses, is to be given only such weight and credit as you think is properly entitled to receive. When scientific, technical, or other specialized knowledge might be helpful, a person who has specialized training or expertise in that field is allowed to state an opinion about the matter. But that does not mean you must accept the witness's opinion. As with any other witness's testimony, you must decide for yourself whether to rely upon the opinion. Prior statements. Kind of important. Kind of important here. Your assessment of a trial witness's credibility may be affected by comparing or contrasting that testimony to statements or testimony of that same witness before the trial started. We got this for the landlord too. Kind of really only through the attorney's question, but the jury heard it. So Doug's question about the broken door lock isn't in and of itself evidence, but it had me thinking. It is for you to decide whether there is reasonable explanation for any inconsistency in a witness's pretrial statements and testimony when compared to the same witness's trial testimony. As with all issues of witness credibility, you, the jury, must apply your common sense and reason to decide what testimony you do or do not believe. And I think that, again, a lot of what we might get into with prior things and whether or not the investigators decide to use it as a lead and sniff it out, we're going to get with this last witness, Tracy Sands. All right, what do we got here? Statement of defendant. Statement of defendant. A statement that the defendant allegedly made while in custody has been offered for your consideration. Before you may consider... Okay, wait, there's also a note here, maybe doing a limiting instruction, conditional admissibility before playing the things. We didn't get a preceding instruction for these interrogations, did we? We just got an emphasis that he was Mirandized. And I think that was in part because Doug's trying to embrace the statements because there's consistent statements made in the May 13th and May 26th interviews. The consistency of the gym, we were being told, I was assaulted, we were afraid, we moved, we changed our names. So I think Doug was embracing that consistency rather than, hey, limit that, I don't want the jury to hear that. A statement that the defendant allegedly made while in custody has been offered for your consideration. Before you may consider this as evidence for any purpose, you must determine whether the defendant's statement was voluntary, and if the statement was given in custody, whether the defendant was properly advised of his or her constitutional rights. I don't think the jury is going to think that those statements weren't voluntary, personally. Voluntariness defined. To be voluntary, a statement must be freely and willingly given and without coercion, duress, threats, use of violence, fear of injury, or any suggestions or promises of leniency or reward. A statement induced by the slightest hope of benefit or the remotest fear of injury is not voluntary. To be voluntary, a statement must be the product of a free will and not under compulsion or any necessity imposed by others. In determining voluntariness, you may also consider to what extent defendant was informed of his or her rights as discussed below, if applicable. Oh, all right, next 5 pages. Again, this is our way of not having to pay for the document. State's request to charge number 12, burden of proof as to voluntariness. And remember, we had the prosecutor ask these questions, I think both times with Tracy Sands before the May 13th and May 26th interviews. Was he under any duress? Was he shackled? Were you intimidating him? I forget the exact questions, but they did get questions and answers on the record. Burden of proof as to voluntariness. The burden of proof is upon the state to establish that the statement was voluntary, that is, freely and willingly made. If you do not find that the statement was voluntary, you may not consider it for any purpose. And again, there was a part where he ends up being shackled at the end of the second interview, but that wasn't shown to the jury. And it was at the conclusion. Constitutional rights. If you find that the statement was made while in custody and as a result of police questioning, you must also determine whether the defendant was advised of his or her constitutional rights and whether the defendant clearly understood and knowingly gave up such rights. The constitutional rights that law enforcement officers must explain and that the defendant must understand and voluntarily give up before any custodial statement is taken by law enforcement are as follows. The defendant had a right to remain silent. If the defendant chose not to remain silent, anything he said, she said, wrote, signed, could be used as evidence against the defendant in court. The defendant had a right to counsel, to consult a lawyer before any questioning, and to have the lawyer present with him or her at all times during any questions. And if the defendant did not have money for a lawyer would have been provided for him/her to represent him/her before any questioning, and to be present with him/her during any questioning. Now imagine if he was like, well, I need a lawyer, I don't have money, but then in the same interview you also said you had like 7 figures. You just had a cool 32 million. And then you have to be like, never mind, I'm actually indigent. Let's hop over to the chat. Shout out to Amy. How you guys doing over there? Are you guys still doing the Kassotis testimony? Aaron says, I think cash out sentencing hearing was a great example of not being able to stop your client from speaking. Guys, if you missed the cash out sentencing, I agree with what Aaron's getting at here. Keratin Matthews represented cash out. Keratin Matthews gave a statement that I think, could have neutralized, could have helped mitigate some of the sentencing. And then cash out wants to speak and address the court. And it just kind of showed the, no remorse, calling people liars, trying to fight. I think it pushed the judge to lean more towards the max than maybe she would have if they hadn't spoken. And likewise, I think the other defendants did the same damage to themselves when they chose to speak. Idiot Win says, I've convinced myself he shouldn't testify. Doug argued he could believe Jim is real, be just as incurious as so many we've seen on the stand. Plus then they do rebuttal and he's so obnoxious. Yeah, so Jenny, I'm not sure about this being private retainer because originally it was the Apt firm that was on this case. Doug ends up starting his own practice, and there's a substitution of counsel filed that's signed by the public defender's office. So I feel like the attorney was always appointed here, and when the defendant in this case wanted to stick with Doug after he moved firms, PD's office had to approve it. So my interpretation is it's actually an appointment rather than private retainer. So that's how I looked at it. Okay. Charge 14, burden of proof. The burden of proof is upon the state to establish that the warnings of all rights mentioned were given, that they were understood and knowingly given up by the defendant. I think I mean, and this is me, this is my opinion. One, if you think Nicholas Kassotis knew he was voluntarily waiving his rights when he sat for those interviews. Two, if you think there's an argument here that, hey, some of that, I don't think it was voluntary. I'm pretty strong a one in that regard. But we'll see. We can differ. We can have different opinions. The next charge is conditions precedent to consideration of statement. If you find, as mentioned above, that the defendant's statement was voluntary and that all of the warnings as to the defendant's constitutional rights were given, that the defendant did understand the meaning of what was said and knowingly gave up such rights, then you may consider it as evidence. If so, then you must apply the general rules for testing the believability of witnesses and decide what weight, if any, you will give to all or any part of such evidence. If you fail to find defendant was properly informed of these rights, and that he understood and gave up those rights, you must disregard the statement entirely and give it no consideration in reaching your verdict, except for purposes of attacking the credibility of the witness for impeachment. DNA evidence. And remember, the evidence here would go to proving it was Mindy Mebane Kassotis. We don't have DNA results for the defendant. So, yeah, lots of ones here, you guys. And again, I think that's part of, Doug obviously looked at this evidence before thinking about strategy for the case. What should we do with this? And I think when you hear the way these interviews start off and how they go on so voluntarily, he's like, all right, it's not gonna, I'd have egg on my face if I walked into the courtroom and in closing tried to argue to this jury that they held him, they intimidated him, they coerced him, they were mistreating him just to get him to say what they wanted him to say. I think that would be a credibility loss for the attorney, and that credibility loss on the attorney could impart on the defendant. So I think a very good decision on Doug's part not to even try to go there. Yeah, I don't think they're going to argue that at all. So let's see, this DNA. Evidence relating to DNA comparison has been admitted for your consideration. Identification by DNA comparison is considered opinion evidence and is governed by the law concerning opinion testimony as has been given to you. As opinion testimony, evidence relating to DNA comparison is dependent upon many factors. Among the factors are both the credibility or believability and accuracy of the witnesses who were involved in the process of obtaining, identifying, preserving, recording, and maintaining the physical evidence, and upon the accuracy and validity of the testing procedures themselves, which were used to form such opinions. All of these issues are matters for you to consider and determine. It's for you to determine what weight, if any, you will give to the evidence relating to DNA comparison in your decision in this case. So on this one, in my opinion, I don't think Doug's going to try to go after, this is not Mindy. I don't think we're going to get that argument. But where I do see this DNA evidence coming into play in closing arguments is, they weren't actually able to tie some of these tools either to my client or to this crime. So arguing some of this evidence could help fight some of the other, like the non-murder counts. For example, maybe they don't think, maybe they just don't think the deer hunting kit was at play here at all. Because remember, that wasn't even a subject tool that was submitted for tool mark analysis. They went and bought their own kit and just said, hey, could this have made these marks? So, but who knows? Who knows? Let's see. Character of the defendant. Evidence of the defendant's character trait of truthfulness, if any, has been presented to show that he or she acted consistently with that character trait in this case. I wonder if they're going to word it like that or just read truthfulness. It's kind of weird. This evidence can come in the form of testimony about the defendant's reputation. So are these crossouts what the state is suggesting as a change? Because this is interesting. For example, it could read as evidence of the defendant's character, if any, has been presented, or evidence of the defendant's character trait of truthfulness. And if this, I see why it would benefit the state to say character trait of truthfulness, because you're anchoring the jury into thinking about, well, was he truthful or not? Whereas if you just say character, that's a slightly different question that could include truthfulness, but that's not the only thing that could go to somebody's character. So this swapping of the words, this little ad-libbing here, I see why they want to use these second parentheticals. For example, this sentence could read, this evidence can come in the form of the opinion of another witness, or it could read, this evidence can come in the form of testimony about the defendant's reputation. Now, connotations for the word testimony, although testimony could be opinion, versus straight out saying opinion, there's different connotations with each of those words, right? Testimony is under oath. Opinion is subjective. So very interesting to see, and not surprising at all that the state would prefer this over this. I want to see them argue this in court. I love getting granular about wording. Let's see. Another one that could have been here was examples of the defendant's conduct which show his or her character or character trait. You should consider character evidence, if any, along with all the other evidence in deciding whether you have a reasonable doubt about the defendant's guilt. So that one was kind of interesting. All right, definition of crime. I'm thinking of Woody, I did these crimes. This defendant is charged with a crime against the laws of the state. A crime is a violation of a statute of the state in which there is a joint operation of an act or omission to act and intention or criminal negligence. Intent. Intent is an essential element of any crime and must be proven by the state beyond a reasonable doubt. Intent may be shown in many ways, provided you, the jury, believe that it existed from the proven facts before you. It may be inferred from the proven circumstances or by acts and conduct, or it may be, in your discretion, inferred when it is the natural and necessary consequences of the act. Whether or not you draw such an inference is a matter solely within your discretion. Criminal intent does not mean an intention to violate the law or to violate a penal statute, but means simply the intention to commit the act that is prohibited by a statute. Let's see. Statute of limitations. Oh. Okay, I was about to read this wrong. I was like, wait, there's a 4-year limitation on murder? I jumped the line here. That's not what this says. Members of the jury, the law of our state set a time limit upon the state in starting prosecution of most criminal offenses. The accused is on trial for the offense of murder. Under Georgia law, prosecution for this offense may be commenced at any time. Prosecution for all the other felony offenses included in this indictment must begin within 4 years after the offense was committed. So this was 2022, so we're within. Prosecution for all the misdemeanors included in this indictment must begin within 2 years after the offense was committed. And the indictment, remember, February. It was February of 2024. I don't know the date. Oh, we've got a B here from our poll back in the chat. Nika, see you when you catch up to us. Nika's in the past. Oh, Jennifer's over here from the Broken Baker. And thank you so much. So Jen is getting used to this YouTube username thing. She said in parentheses, Jen Pookie. So thank you for doing that. And good to see you hanging out over here. Oh, wait, did this jump? I think I missed a... It's just talking in mid-sentence. I think I missed a page. Okay, yeah. So venue. The law provides that criminal action shall be tried in the county in which the crime was committed. In a prosecution in any case in which it cannot be determined in what county the crime was committed, venue is proper and may be proved in any county in which the evidence shows beyond a reasonable doubt that it might have been committed. Venue, that is, the crime was committed in Liberty County, is a jurisdictional fact that must be proved by the state beyond a reasonable doubt as to each crime charged in the indictment. And remember, the prosecution started explaining this charge in their opening. Venue must be proved by direct or circumstantial evidence or both. Venue special circumstances. Crimes committed on the boundary line of two counties. So we got a little bit in the Megan Jackson trial, the coroner co-conspirator murder trial of this venue issue. If a crime is committed on or immediately adjacent to the boundary line between two counties, venue is proper and may be proved in either county. So Liberty and McIntosh are the two counties here. Criminal homicide. Criminal homicide shall be considered as having been committed in the county in which the cause of death was inflicted. If it cannot be determined in which county the cause of death was inflicted, venue is proper and may be proved in the county in which the death occurred. If a dead body is discovered in the state and it cannot be readily determined in what county the cause of death was inflicted, venue is proper and may be proved in the county which the dead body was discovered. So important there, they don't need to prove for homicide, where this county, that county. Crime commenced outside the state. If the commission of a crime under the laws of the state commenced outside the state is consummated within the state, venue is proper and may be proved in the county where it is consummated. Crime committed while in transit. And this stuff is kind of cool. If a crime is committed upon any railroad car, vehicle, watercraft, or aircraft traveling within the state, and it cannot readily be determined in which county the crime was committed, venue is proper and may be proved in any county in which the crime could have been committed, through which the rail car, vehicle, watercraft, or aircraft has traveled. I feel like, are they covering all the vehicle types here? Are we missing any? Crime committed on water boundaries. Whenever a stream or body of water is the boundary between two counties, the jurisdiction of each county shall extend to the center of the main channel of the stream or the center of the body of water, and if a crime is committed on the stream or body of water and it cannot be readily determined, and I don't think we really got to bodies of water. Like, I'm sure there's bodies of water, but I don't think any of the parts were found near bodies of water. Crime committed on water boundaries of two states. We can skip that. Verdict. So what's the jury's job? If, after considering the testimony and evidence presented to you, together with the charge of the court, you should find and believe beyond a reasonable doubt that the defendant in Liberty County, Georgia, did on or about the 29th day of November 2022 commit the offense of malice murder, felony murder, aggravated assault, concealing the death of another, possession of a knife during commission of a felony, 5 counts of possession of tools for the commission of crime, removal of body parts from scene, and tampering with evidence as alleged in the indictment, you would be authorized to find the defendant guilty. In that event, the form of your verdict would be, we, the jury, find the defendant guilty. If you do not believe that the defendant is guilty of any of these offenses, or if you have any reasonable doubt as to the defendant's guilt, then it would be your duty to acquit the defendant, in which event the form of your verdict will be, we, the jury, find the defendant not guilty. So, the court has no interest in case. By no ruling or comment that the court has made during the progress of the trial has the court intended to express any opinion upon the facts of this case, upon the credibility of the witnesses, upon the evidence, or upon the guilt or innocence of the defendant. I don't think we've had much, because there haven't been so many objections, I don't think there's really been, whether the court would express an opinion here or not, there's really been no opportunity for the judge to, sit up there rolling eyes or sighing into the microphone like we've seen in some other cases. You chat might know some examples. Sympathy. And this is an important one, I think. I think Angela Wynn, who we saw testify today, and a little bit with Morgan Paddock, and even the parents, even though they didn't seem so emotional to me, just because they're parents that lost a child, the sympathy instruction, I think, is pretty critical here. Your verdict should be a true verdict based upon your opinion of the evidence according to the laws given to you in this charge. You are not to show favor or sympathy to one party or the other. It's your duty to consider the facts objectively without favor, affection, or sympathy to either party. In deciding this case, you should not be influenced by sympathy or prejudice because of race, creed, color, religion, national origin, sexual preference, local or remote residence. Yes, so don't judge these people from being out-of-towners. Economic or corporate status for or against either party. And again, likewise, this would mean don't sympathize with the defendant just because he lost his wife. 25, sentencing responsibility. Let's see. You are only concerned with whether the defendant is guilty or not guilty. You are not to concern yourselves with punishment. So that's pretty standard. I wish it told us where we were. Because it lets me do 5 pages at a time. This is 49 pages. Deliberations. You guys know the deliberations. You're not supposed to talk to each other. Unless you're actively deliberating. But if you're on a break and not actively deliberating, don't continue to talk about this case. Don't talk when a juror's missing from the room because they went to the restroom. Malice murder. Let's see the wording here. For malice murder, the state must prove that the defendant 1. Caused the death of another person, 2. Unlawfully, and 3. With malice aforethought. The killing must have been done with malice to be murder. Malice, as the term is used here, is not necessarily ill will or hatred. Rather, it is the unlawful intent to kill, without justification, without excuse, without mitigation. You may find malice when the circumstance shows that the defendant acted with the deliberate intention to unlawfully take the life of another person. You may also find malice when there does not appear to be significant provocation, and all the circumstances of the killing show an abandoned and malignant heart. The state does not have to prove premeditation to prove murder. If a killing is done with malice, it is murder regardless of how briefly the malicious intent existed. No specific length of time is required for malice to arise in the defendant's mind. Malice may be formed in a moment, and instantly a fatal wound may be inflicted. If malice was in the defendant's mind at the time of the act or killing, and moved the defendant to do it, that is enough for the killing to be murder. So a case, and it hasn't been tried yet, but a case I like to use as the example here is the Courtney Clenny case, where, immediately after she seems to be in panic, Courtney Clenny seems to be in a panic. She seems to genuinely want to save her boyfriend's life. But in that moment when she plunged and or threw and or flung the knife in his direction, was she intending to cause him harm? And because she's using a knife, it's presumed that the harm that she would inflict has the high likelihood of being deadly or causing serious injury. So, in that instant, I think it's going to be very hard for a jury to find that she wasn't acting with malice in that instant, even though right after she does sincerely appear to regret it, to not want that to be happening to her boyfriend. So, interesting. I think this one is a bit tough to get to, though, because even watching in the chat, people are like, why would he kill Mindy, though? So, interesting. Premeditation. We'll read a bit about premeditation. Also, shout out to Classy Beats. Let's get some W's in the chat for Classy. Dropping. You must have ended the stream. Let me know what you thought about the tool mark analysis. Because I think this case is crazy. I think there's some really bad facts and kind of bad vibes against this defendant. Right? Like, I think you never know. The jury could just be like, we think he was such an asshole to his third wife that we don't really care if he used the tubs or not. Let's just convict him on all of these things. Like, he's an asshole. You know, who knows? All that being said, though, when I look at a tool mark analysis testify, and I'm like, does this really tell us as much as the state wants us to think it tells us? So it's always weird to just kind of process expert testimony kind of in a bubble apart from the case itself. Look at all the love here for Classy. There we go. Yeah, and I think the word for this trial undoubtedly is crazy. I don't think anybody would disagree with that. And you guys, I'm sure you already, if you're not, I'll be upset with you. If you're not already following Classy, there's a link in the chat for you guys to get over there real quickly. I still have trouble searching for you as Classy. I still have to type Classy Beats, even though I'm subscribed to you to pull you up. So guys, if you're trying to find Classy's channel in a search and you struggle, try Classy Beats, spell it out, and it'll pull up. So, oh yeah, so we just went over that, Classy. So he's got 5 counts of tools. You've got the insulation knife that was purchased on the 29th, the 7-piece deer hunting kit. You've got the Ford Explorer. You've got the tubs, which they're treating as one tool together, and the shovel. So those are the associated, each of the counts for using tools in commission of a crime. Those are the tools being specified. So a whole time. And again, this is the state's proposed charges. So we'll see if Doug has anything that he would want to request in addition or have reworded. Let's see. So premeditation. Premeditation typically means a prior decision or plan to do something. Premeditation is not an element of murder and does not need to be proved by the state for you to find malice aforethought. However, in determining whether malice existed at the time of the killing, you may consider any evidence of premeditation or lack of it. And this charge should only be given, this is a bench note, so the judge should follow this. The charge should only be given if the jury requests a definition of premeditation. So, probably won't hear this read, but I don't know. I feel like jurors always want premeditation, malice, these surrounding terms defined. Motive. The state does not have to prove motive to prove murder. Any evidence of motive has been admitted for your use in determining the defendant's state of mind at the time of the killing. I'm not gonna lie. I think when the state's telling us, they're trying to tell us there's this blood on the futon and that we can make this inference that the murder and possibly the dismemberment occurred in this Airbnb rental on 65th Street. I don't really think they put evidence on the record of motive. They kind of gave us a motive of why they were a unit together. Mindy, Nicholas, both running from the $1.5 million judgment from the first marriage was the argument in openings. Even though I think they could have, they mentioned that he moved on. They didn't make the argument in opening. They said they were on the run, but they didn't make the argument that, oh, the defendant wanted to kill Mindy to move on to be with Samantha without issue. I think they could have argued that, but they just didn't. And I thought that was kind of weird because it's there. It seems like, I don't know. Do you guys think it happens that people kill somebody so they can move on and be in another relationship? I think that would be more sensible to argue than we were on the run, but then I killed the person I was on the run with. So felony murder. For felony murder, the state must prove that the defendant caused the death of another person by committing a felony. The state does not have to show that the defendant acted with malice to prove felony murder. Aggravated assault is a felony, which I will define for you shortly. Let's see. Causation in felony murder. You may find the defendant guilty of felony murder if you believe that he or she caused the death of another person by committing the felony of aggravated assault, regardless of whether he or she intended the death to occur. There must be some casual connection between the felony and the death. Felony murder is not established simply because the death occurred at the same time as or shortly after the felony was attempted or committed. The felony must have directly caused the death or played a substantial and necessary part in causing the death, regardless of when the death ultimately occurred. Aggravated assault with a deadly or offensive weapon. And I think this is where they were hinting, there's the blunt impact at the back of the head, and there was a purchase of a fiberglass hammer, and let's make the inference. For aggravated assault, the state must prove that the defendant assaulted another person with a deadly weapon. And we'll see how they argue this in closing. To prove assault, the state does not have to prove that the other person was actually injured. However, the state must prove that the defendant attempted to cause a violent injury to the person, committed an act that placed the person in reasonable apprehension or fear of immediately receiving a violent injury. An offensive weapon is any object that is likely to cause, or actually does cause, death or serious bodily injury if used against someone. And we got bench notes here to include the definition of offensive weapon, only if required by the indictment. Possession of knife during the commission. So they have to prove that they had a knife with a blade at least 3 inches long on his or her person within arm's reach while attempting to commit a felony, which is one of the following: a crime against or involving another person. Concealing a death of another is a felony, which I will define for you shortly. So again, this possession of a knife does not mean the knife had to be used to murder Mindy. It could be possession of the knife to carry out the hiding of the death. Concealing the death of another. For concealing the death of another, the state must prove the defendant concealed the death of another person, which hindered the discovery of whether that person was unlawfully killed. We got bench notes that gravamen of the offense is conduct that hinders a single discovery of a single unlawful killing. And it says, do not give this charge in the sentencing phase of death penalty or life without parole cases. Possession of tools. For possession of tools for commission of a crime, the state must prove that the defendant, 1, possessed tools as alleged in the indictment. So they've got to go with what's alleged. It's attached to the caption of the counts. So if they say Ford Explorer, we can't just say, we think he used something else to transport for that particular count. 2, commonly used to commit the crimes alleged in the indictment. And 3, with the intent to make use of said tools in the commission of said crimes. Let's see. Hey, Heart of Inspiration. Oh my gosh, Heart of Inspiration, good to see you. Hope you've been well. This is a crazy case. I can only imagine your takes. Guys, Heart of Inspiration, friend of the channel. Let us know what you're working on. Let us know what you've been up to lately. It's good to see you. We've got Classy saying, all right, let me go back to the beginning. So family and friends backed up Nick's story. Mindy even told her friends and family what was happening. And this was a question I had. I wish I could just zoom real quickly to day 1 and watch myself with the past fog. And I was like, well, was Mindy only reciting to her family indirectly? So Nick told me this, I believe it, and I'm relaying that stuff that I believe but didn't witness firsthand. Do I relay those things to my friends and family? And as the trial moved on, we've gotten repeated testimony. I think the dad told us multiple times, the mom told us a few times. We just had her best friend tell us. It seems like we had both the JAG officer from this morning Chris with the name I can't caps lock. And then Mindy's former employer, where she worked as a legal assistant. They both told us that it seems like Mindy was also experiencing this fear, something to cause her fear, and wanting to change her identity and make sure her communications wouldn't get intercepted. That was coming directly from Mindy. It wasn't just a hand-me-down that she believed and trusted her husband about and relayed on indirectly. So that is really interesting. And I didn't expect to get so many witnesses to say as much. So Classy says, so either she was extremely manipulated by Nick, or Nick is telling the truth. The state hasn't really proven Nick manipulated her, so either option isn't good for them, in my opinion. And it's weird, we're not getting any... I feel like a case like this you'd hear, was there past violence? Is this... we're missing things that, if this was a DV case, and obviously, like, dismembering a partner would be domestic violence. It'd be violence against a partner. But we're missing any sort of, like, no history of a tumultuous relationship, no indication that they were wanting to separate from each other. Maybe the closest thing, Nick mentions in July 2022 bleeding and says they were told it could have been an early miscarriage. So maybe there was some type of switch, a mental switch, because maybe there was a miscarriage in July 2022. And both Mindy and Nicholas were in disbelief about the miscarriage, continued to tell people they had a due date. Both continued to tell people there was a due date of January 8th. And it eventually just got to be too much. And it just... but other than that, I don't even see where we can make an inference besides knowing that Mindy's dead. That there was, like, a history of toxicity between the two in their relationship. It's just really weird. So, I'm trying to approach that delicately, but it's, I watch a lot of cases where, sometimes it's hearsay and you get an expert to say, hey, you might not ever actually have a victim report something, but we don't have an expert getting up there in this case. We don't have a DV, IPV expert witness in this case. And I also think it's pretty interesting. We've heard the state, she was not pregnant, she was not pregnant, she was not pregnant. It's not like they're sitting up here and trying to add on an extra charge because a fetus, a baby, was impacted by this whole transaction. So, and I mean, shout out to the state for not trying to over prosecute, right? If they really don't believe there was any evidence of pregnancy at the time of Mindy's death, shout out to them for not trying to over prosecute. And is this another 5, Classy? Holy moly. Let's get more W's in the chat for Classy. He's over here sharing his insights, watching this trial as well over on his channel. Dee's over here too. Good to see the Classy fam. Good to see you. Dropping 5 gifted subs. Make sure you guys are saying thank you. And again, make sure you go check out his replays. I tend to cover a block of a trial all in one. He does a variety show, you guys. So if you're looking for, like, get up to date on what's going on in this case and anything else that's worth talking about, love the style of his shows. He holds it down over there. So make sure you show his channel some love. And Amy E, if she's still in the building. Always love to see Amy E. Let's see. Idiot Win says, I think the friend's testimony reinforced for me that she did just believe him and was hopeful about the future. And I get that there was resentment. When Doug gets up for cross, it was clear, and I don't fault her at all for it. But I think Angela's testimony reinforced that Mindy herself was speaking on this, hey, we've got things that are going on. We're dealing with something where we need to be high security. And she's telling this to the friend, her best friend. So, and I don't really see a reason to believe that Mindy wanted to, at least not in evidence on the record here. I've seen some out-of-court commentary that maybe Mindy and Nicholas were both, like, LARPing. They were role-playing this out. They were just live-action role-playing. But as far as what's in court, and where I don't know if I really believe in the LARPing, theories that I've seen. What reason would there be for Mindy to lie to her best friend and keep the lie going for so long? So I don't know. I don't know. And thank you for all the W's here for Classy. Love you guys. Look at all that love. Shout out to the Classy Beats. The Classy. It's weird because your name with this @ thing, it's Classy Beats again. I was just getting used to just calling you Classy without the beats, but here we go. It's all back to your original name. Doug may or may not have Nicholas, well, it's not his decision. Doug said he doesn't plan on calling the witnesses that he provided in his list, but that Nicholas may or may not decide to take the stand. We don't know yet. So, oh, and shout out to the Doug. In most criminal trials, the defense is presented mostly through cross-examination of the state's witnesses. And I think this is the prosecution was like, court, can we please have the jurors come in late? Our witnesses have to fly in, and we really, really, really want to put Tracy Sands on the stand last. And we were talking about that, chat. That's strategic for the state, but Doug is very experienced with using cross-examination to deliver his case. We saw at the YSL trial. And I think this is Doug's 4th murder trial. No case in chief for the defense, but they had a ton of cross-examination that did a lot of damage to the state's case. So if the state wants to end with this lead investigator from the prosecution's office, Tracy Sands, I think there's a lot of room for Doug to cross-examine. So it would be an interesting way to close out the state's case in chief. So JC, this has been, I don't know. I've gone into chats where I see this @ name on YouTube happen, and then I go back to that same channel and it's not happening, and then it's happening again. And I was in the clear for like 2 weeks, and then all of a sudden it hit my channel. And I'm like, I'm so grateful that like I'm remembering pictures and faces, and almost everybody has a similar name. Like, you know, you've got the J in your name at least. Jeevy's got her name. Dizzy has Dizzy in her name. You know, Classy has Classy. Yeah, and Jennifer, I still love when Jennifer joined the chat earlier. She put her AKA name. Super love that. Oh my goodness. Yeah, it's a YouTube thing, you guys. If there's a way to disable it, that'd be great. Because I am a little worried. I don't want to read anybody's @ name without thinking, and it like gives out more information than they thought would be publicly displayed. So let's see, we've got removal of body parts from scene of death or dismemberment. It shall be unlawful for any person to remove from the scene of the death or dismemberment of any person any human body part, provided, however, that this code section shall not apply to a law enforcement officer acting in the lawful discharge of his or her official duties, or to any person acting under the direction of a law enforcement officer, a physician, or an emergency medical technician in the course of their professions, or in the absence of any such person, to any person who transports such body part directly to a medical facility. I was waiting. I was like, so what if someone thinks someone's dying, thinks they're still alive, but they're actually dead, and they like move the body to go to a hospital? I was ready, but they cover that. Law enforcement agency or licensed funeral home. Although all such persons remain obligated to comply with the provisions of Article 2 of Chapter 16 of Title 45 concerning death investigations. Let's see. Tampering with evidence. A person commits the offense of tampering with the evidence when, with the intent to prevent the apprehension or cause the wrongful apprehension of any person, or to obstruct the prosecution of defense of any person, he knowingly destroys, alters, conceals, or disguises physical evidence, or makes, devises, prepares, or plants false evidence. So, I don't know. Do we get a little bit of Jim theories coming into play here? Nothing in this code section shall be deemed to abrogate or alter any privilege which any person is entitled to claim under existing laws, except as otherwise provided in the subsection. Any person who violates subsection A of this code involving the prosecution or defense of a felony, and involving another person shall be guilty of a felony, and upon conviction thereof, shall be punished by imprisonment of not less than 1 nor more than 3 years. Why is this in here? Why is this in here? They must have made a mistake and not clip this out. Like, they shouldn't be talking about the terms, length of sentence. But okay. I think they made a mistake there, but so maybe they'll fix that one up. Let's see. Request to charge 38, proof of murder weapon by circumstantial evidence. So this is relying on case law rather than model jury instructions now. So suggested from Allen v. State here and Brown v. State. The state need not admit into evidence the weapon used by the defendant in order for the defendant to be found guilty of the crime involving the weapon. So if they want to say deer hunting knife was used, well, we don't need to enter the actual deer hunting kit for the jury to find beyond a reasonable doubt that he's guilty of doing this crime with that deer hunting kit. The presence of a deadly weapon, this is from Eccles v. State. The presence of a deadly weapon or the appearance of such may be established by circumstantial evidence. So like the receipt, the purchase from Bass Pro Shops. And a conviction for aggravated assault may be sustained even though the weapon was neither seen nor accurately described by the victim. Polygraph? Hold on, chat. Did we heard about the polygraph outside the presence of the jury, but is anything on the record? I mean, maybe they're just putting this in here to make sure they cover bases in case it comes up during Tracy Sand's testimony. I think the state thinks Doug's going to get up there and be like, my client took a polygraph test. So maybe that's where they're getting ahead of what they expect Sand's testimony and cross-examination to touch on. Because otherwise, with the interrogation where he said he would take a polygraph, they redacted that out. The jury didn't get to hear that part. So this will be fun to see if this comes up on... Put it on your bingo card for Tracy Sand's testimony. The general rule in Georgia is that the results of polygraph tests, whether favorable or unfavorable to an accused, are not admissible in evidence as they are not considered reliable. We got some cases there. Oh! Raising mental defenses. Here we go, chat. The law requires that when a mental defense is raised, the defense must first give notice of its intent to raise that defense with the court. That includes a claim of mental incompetency to stand trial as well as a claim of insanity. There's been no such notice given in this matter, and therefore neither of those issues is relevant to your deliberations. So, nope. If there's that juror that's like, I don't think he's competent, I don't feel right. Nope, you're not supposed to consider that. All right, let's see. And that's more case law. All right, and we're on the last 3 pages here, which is going to take us right up to the 1 o'clock ETA of the next witness. False statements, consciousness of guilt. A false explanatory statement may be viewed by you, the jury, as substantive evidence of guilt. When a defendant voluntarily and intentionally offers an explanation, and this explanation is later shown to be false, you may consider whether the circumstantial evidence points to a consciousness of guilt, and the significance to be attached to any such evidence is exclusively within the province of you, the jury. Moreover, wholly incredible explanations may also form a sufficient basis to allow you to find that the defendant had the requisite guilty knowledge. What do you make of that line, chat? Wholly incredible explanations may also form a sufficient basis to allow you to find that the defendant had the requisite guilty knowledge. So I feel like we're going to see the state use this language in closing. They're going to say, wholly incredible explanation about Jim. They're going to use this wording. That way when the jury thinks like, hey, we can find that wholly incredible thing, if we think it's wholly incredible, is consciousness of guilt. So let's listen for that language in closings. This court expresses no opinion whether any false statement has been made in this case, and that matter is solely within your province to determine. Exact date of murder is not material. The exact date on which the murder took place is not a material element of the crime of murder because there is no statute of limitations for murder. This means that the state does not have to prove beyond a reasonable doubt the exact date on which the murder took place. And video testimony. The state and the defense have agreed to allow one or more. When we heard an instruction briefly on this for the last witness that we saw. They agreed to let someone testify via video during this trial. You are to evaluate the credibility of witnesses testifying via video just as you would any other witnesses. If you find the testimony to be credible, the testimony of the witnesses testifying via video should be given the same weight as credible in-person testimony. In other words, testimony of a credible witness taking place over video should not be devalued merely because the witness did not testify in person. And there we go. Those are the ends of the proposed instructions. So we'll load back up. We'll see what's going on. If we get a witness around 1 o'clock. And also, should we, yeah, okay, so Law and Crime still says 1 p.m., but this is their older message, so